Welcome and thank you for joining Seyfarth's webinar, Managing Trade Secrets in a Remote Work Environment. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Kate Pirelli. Kate, you may begin.
Thank you, Sadie, and welcome everyone. We're delighted to have you with us today for this topic on managing trade secrets in a remote work environment. This was a topic that became number one on our priority list during COVID and the shutdown. But it was a situation that existed before COVID, and it will exist now and exist in the future. And it's time for businesses to pay attention to these conditions and make sure that they are protecting their trade secrets while people work away from the office environment, the formal office environment. Next slide, Sadie. I'm going to take a moment to introduce the panel. As Sadie said, my name is Kate Pirelli. I'm a partner in the Boston office of Seyfarth Shaw. Seyfarth is an international law firm with 10 plus offices in the United States and several internationally. You've got an all Boston team here today, but all of us work on these issues across the country, both counseling as well as litigating issues. I'm resident in Boston. I'm the co-chair of our trade secret non-compete practice. As I mentioned, I counsel clients in these areas, both in terms of how to protect the trade secrets, but also how to enforce agreements relating to them and litigate them across the country, both in state and federal courts. Dawn Mertenite is also a partner in the Boston office. Her practice, she's the co-chair of our award-winning trade secret blog. I'm going to let her say a little bit more about that when it comes to her speaking role. She'll direct you to the website for that. Dawn has a practice similar to mine, and we work together on a lot of these cases across the country, and have given this presentation a number of times actually in various venues. Kat Johns is an associate in our Boston office. She is a complex commercial litigator. She is also working in the trade secret area now and non-compete area. The three of us often partner together on cases both in Boston and elsewhere. And prior to joining us and working with another law firm, she was an appellate law clerk, and I can let her tell you about that when she speaks as well. But let's go to the next slide. And this is the agenda for the program. Kat's going to kick it off with an overview of trade secrets and what they are and how to think about them. Dawn and I will say a little bit, she'll go next in the challenges in a remote work environment area, and I'll finish it off at some point in section 2 and 3 on trade secret protocols and some things to think about as you tackle this topic for your employee base. So I'm going to kick it over to you, Kat, and you can go to the next slide, Sadie.
Great, thank you, Kate. So I'm going to take this first agenda chunk that we have, which is an overview of trade secrets, a little bit of background. If you've ever been in some trade secrets litigation, first, wow, how fun. But secondly, some of this might be things you've heard before, but it never hurts to revisit. And it never hurts too, while we're talking about, as Kate mentioned, this new normal where we're not in the formal office so much, kind of teeing up the way there have been some changes in some of this background and how there might be some more on the horizon as well. So we can go to the next slide. And we're starting here with what is a trade secret? And I may have a more difficult task than I thought today, in that it's not always the simplest thing to clarify. This judge had the nice wording of a trade secret is one of the most elusive and difficult concepts in the law to define, which may be true. But at the same time, it's not entirely the Wild West out there. There are some guideposts and parameters for analyzing whether a particular company asset or set of information is in fact a trade secret. So let's get into some of those on the next slide. When we're talking about trade secrets, the statutory background, what's going to come up is the Defend Trade Secrets Act of 2016, which is a federal statute for insiders, which we are allowing all of you to become in this session. It's the DTSA. And what's nice about the DTSA statutory language, there's a couple of things. First of all, at this point, it having been out a couple of years and maybe even from moving in that direction towards the federal legislation, state legislation tracks this definition pretty well, sometimes almost exactly, which is convenient. So when you're looking at DTSA case law or background, it's often useful regardless of jurisdiction. Another thing that's nice about this definition, depending, is that it's very broad. So if you look here at this chunk, this is the direct quote of the definition from the DTSA. And you'll see that it's not just sort of the Coca-Cola secret formula, right? A trade secret can be a variety of different things. It can be a device, it can be a prototype, and that it goes across a lot of industries. It can be scientific knowledge, but it can also be economic knowledge. And when we're deciding if, asset A is or is not a trade secret, what a court is going to prioritize is this two-part test that you see here at A and B. And this test is handy, right? Because it divides into trade and secret, which is convenient. So A is sort of the secret component. So the owner of the trade secret has to take measures that are reasonable to keep the trade secret secret. And then B, moving into the trade component, is that the trade secret has to have independent economic value. And that's by virtue of the fact that it's secret. So when someone is purloining the secret, which is one of my favorite verbs, when someone is purloining the secret, what they're getting is this economic value of the information. So we can look into some specific examples that are on the next slide of things that might fit into this definition. So we put a lot of them up here for you, obviously not an exhaustive list by any means, but I think this does show how broad that definition can be under the DTSA and under state legislation. So the definition can be a little wiggly for better or worse, right? On the one hand, we don't have an exhaustive list of, for a fact this is going to be considered a trade secret and for a fact this is not. But on the other hand, you can make a very fact-intensive argument to the court about maybe things that aren't traditionally or sort of in the common parlance seen as something that's a trade secret, right? So for instance, a customer information list is a wee bit different from the Coca-Cola secret formula, sure. But you can see how this would be keys to the kingdom, right? This could be something that a lot of time and effort and money is put into developing. And, again, going back to the two-part test, that a company would take reasonable measures to keep secret, and that would have obviously tremendous economic value in and of itself. So the key here is not necessarily what the information is or what it looks like. It's does it fit into the two-pronged test? So let's jump into the first factor of the two-pronged test under the DTSA. But before we do that, let's talk about why it's important and how important it is. This slide tells you, pretty important. Trade secrets have to be secret. And we go out of our way to say this because this is going to be key to any court's analysis, even from the very beginning. Walking in and presenting something as an alleged trade secret. If it's publicly available, that's going to be a very difficult argument to make, right? Axiomatic that without secrecy, there's no trade secret. I think this last quote is interesting too, because it shows that this need to take reasonable measures extends even into litigation about the trade secret, right? So at every stage, sort of from the birth of the trade secret to whenever, right? There has to be some sort of intentionality about keeping the trade secret actually secret. But have no fear. The purpose of today is that we will tell you how to do this. So we'll go to the next slide. This is kind of going into what reasonable measures look like when we're talking about reasonable measures to keep a trade secret secret. We included this precious pup to show that you don't have to be a superhero when you're taking security measures to prevent theft of a trade secret. You just need to act reasonably under the circumstances. That's the key language. So what's important here, and especially as we're talking about hybrid work and moving into hybrid work, is that obviously circumstances have changed quite a bit. The entire, look of modern work is different than it was even like 5 years ago, right? So as we're in this remote hybrid environment, especially, the influence of technology is really key. And what's important to note is that it's not just the introduction of technology that's changed what might be reasonable under the circumstances, but it's the type of technology or advances in technology. So for instance, something now, measures that are reasonable now may not be reasonable even if they're technological some point in the future. So it's important to kind of analyze what you're doing on a semi-frequent basis to make sure that you're being, quote, reasonable under the circumstances. So we're going to cover in detail what those things might look like, but I'm going to tee up a couple of them here, these prevention protocols that are really important to put in place. So some examples of things that might help out here would be confidentiality agreements or other employment agreements, some employment policies that are more general, reminders about the existence of those agreements or policies. You don't want to have a situation where an employee heard about their confidentiality policy when they started in 1974 and we haven't discussed it again. You want to make sure that this is top of mind because that also goes to, hey, this is a secret for us. And of course, going back to technology, in a sense, hybrid work through technology has made it easier than ever, unfortunately, to walk away with the keys to the kingdom. But at the same time, it's also kind of provided all of these new and interesting mechanisms to monitor things. So there's monitoring software, there's password protection, there's like two-factor authentication and other tech things that I am not an expert in, but they exist. And these are just examples of ways that you can adjust to modern circumstances and prove that you're taking these reasonable measures. What the second half of this slide focuses on, again, going back to not being perfect, right? No court is going to demand that there was perfect protection of a trade secret, just reasonable protection. So that means leaks of trade secrets might occur. And the key when those leaks occur is to respond. So minimize the damages and minimize them quickly. What's going to hurt an argument that something is a trade secret is if it's publicized and nothing happens, right? That definitely counteracts the idea that it was actually a secret. So when something is leaked, when something is publicized in some way, a court is going to look for evidence that you responded in kind, that there were steps taken to respond to the leak. So we're going to move into emphasizing why all of these things are particularly critical in the remote work environment. And here's a big one, economics. I'll nod to my Southern upbringing here and say that one reason this is all important is that it ain't cheap. The theft of trade secrets has an economic impact of 1 to 3% of the national GDP, which is a pretty penny, right? So these are things we want to keep in mind when we're knowing, like I mentioned before, that theft may be easier than ever as we're moving into a less traditional workplace. At this point, though, I'm going to pass the torch to Dawn, who's going to dive more into these risks and how we can respond to them.
All right. Well, thank you, Kat. That was great background. And before we dive into the nitty-gritty of what the challenges are and how best to protect against trade secret misappropriation, we wanted to pause here and talk a little bit about why we're even having this webinar. Why is this so important right now? Well, typically trade secrets are some of, if not the most valuable assets that a company has. The way that you differentiate your products or your services typically is secret. Perhaps there's some software or source code that makes your product a better product, and you obviously don't want your competitors to know what that is. As Kat said, it could be a formula, a recipe. Perhaps you have some food and you have some amazing way to make it better than your competitor. We think about the classic soft drink recipe and how that is so critical. It's not just the big companies that have trade secrets like that. It can be anyone's trade secrets. So it obviously makes sense that you want to protect that because, again, if you lose that, then you lose potentially your competitive advantage. Another reason this is important is, sure, there are steps that you can take, and we'll talk about them, to minimize the damage after a trade secret has been misappropriated, but it is often difficult to detect that. And to harken back to what Kat said a minute ago, technology has changed. 30 years ago, it may have been that you would see somebody walking out the door with a banker's box full of documents. That's pretty conspicuous. Nowadays, that's not how most trade secret misappropriation occurs. There are much more invisible ways to do it. And as a result, it's harder for companies to detect it and then act quickly. So we want to be implementing protocols that are going to make it harder from the get-go. And then, of course, once a trade secret is out there, you can't put the cat back in the bag. Again, as Kat said, when the trade secret is no longer a secret, well, it's no longer a trade secret in that case. So it really is important to be taking proactive measures up front to prevent any of that information from getting out. And then finally here, you'll see trade secret litigation is very expensive. Typically in these cases, you would want to be filing a motion for injunctive relief, whether that's a motion for a temporary restraining order or at least a motion for a preliminary injunction. Those motions have to be filed quickly because, again, the idea is you're telling a court, this is so important, we can't wait for the normal timeline of litigation to pursue in order to address this issue. We need something right away. We need to be heard immediately. And, you know, the faster things move in litigation, the less efficient they are. You have more resources devoted to them, less time. And even after you get past those initial pleading stages of filing the complaint, filing a motion for a temporary restraining order or a preliminary injunction, there are other things that are expensive. You often have experts involved. There's expedited discovery frequently. So again, it's important to try to avoid this if you can. So let's move to the next slide. Another reason this is so important, you know, we will talk a little bit later. Kate's going to talk a little bit about using agreements with employees to help prevent trade secret misappropriation. One of those agreements is a non-compete agreement. And we still think in jurisdictions where they're appropriate, that's a good way when reasonably limited to prevent trade secret misappropriation. But as you may know, those sorts of agreements are being challenged right now. You may have heard that the Federal Trade Commission earlier this year proposed a rule that would ban non-competes, and even beyond non-competes, what they call de facto non-competes. And some of the examples that the FTC gave are non-disclosure agreements, which is very concerning to attorneys that work in this space, because obviously non-disclosure agreements seem like something that should not be terribly controversial. But the FTC has indicated if those are broad enough, they could be seen as a de facto non-compete, and in almost all circumstances with very, very limited exceptions, the FTC is proposing to ban them. Now, just to avoid any panic here, the proposed rule is just a proposed rule. Nothing has been implemented. There was a comment period. Thousands and thousands of comments were submitted to the FTC, many which were opposed to this proposed rule. And we suspect that the FTC won't implement anything likely until 2024. And even then, this will likely get caught up in litigation. It might go to the Supreme Court. I have my doubts that the FTC is actually going to have the last word on this, but that's something to be concerned about. Similarly, just recently in the last week or two, the General Counsel of the National Labor Relations Board issued a memo suggesting that non-competes, and again, even other types of restrictive covenants, could violate an employee's right under Section 7 of the National Labor Relations Act. So again, you're seeing these federal agencies taking aim at one of the tools that we suggest employers use to prevent trade secret misappropriation. And then finally, this has been a hugely active area for state legislation, as well as Congress as well. But in the states, there have been a number of bills that have been passed that limit non-competes. Most recently, Minnesota issued a non-compete ban that goes into effect on July 1st with very limited exceptions. And New York, when we were preparing these slides, at the time that we did it, New York, the state Senate had passed a bill banning non-competes, and things have changed even since then. Yesterday, I believe it was, the state assembly also passed the bill. So now it is just waiting for the governor to sign it. We suspect that she will, so stay tuned for that. And this is a good place for me to put in a plug for our blog, which is tradesecretslaw.com. You can get updates on state legislation, federal legislation, important cases, things like the FTC and the NLRB. So,
hey, Dawn, can I add one point on that last slide before you go on to the next?
Sure.
Just on the NLRB General Counsel memo, it's available online. You can get it. I just want to point out that it is far-reaching. It is a GC memo at this point, obviously, but it is potentially applicable, according to the NLRB, in non-union settings as well as to supervisors in union settings. So it is far-reaching. It is, I think, also will be challenged. There's one enforcement action that's already been started under it and has settled. It was reported by Bloomberg. Was a very broad agreement involved, but it not the topic for today. But keep an eye out for that and take a look at that memo when time permits. And we will be doing another webinar on these topics, probably July, August timeframe. So stay tuned. You'll get news of that on the blog as well that Dawn just mentioned. Go ahead, Dawn.
Yeah, and I should mention also in connection with that memo, that just like the FTC's proposed rule, that does not have the binding force of law just because the NLRB's general counsel has said that she believes that non-competes violate the NLRA for most employees doesn't mean that courts are following suit necessarily. And the process is long and arduous for a company's use of non-competes to be deemed to be a violation of the NLRA. But it just shows that there is a priority now with certain federal agencies, and again, like I said, certainly in state legislatures, to curtail or ban non-competes for certain classes of employees. So moving on, we're going to talk now about the unique challenges in a remote work environment. So let's go to the next slide. Thank you. Again, this has in large part become a big issue because of the pandemic. You know, and it's certainly, even though we're past the early days of no one leaving their house for weeks on end, this is something that's not going away. I think most employers still have a hybrid policy. There are still employees that will be working full-time from home. And I suspect that many employers are going to have employees that at a minimum are working from home once a week, twice a week, as the case may be. Part of that is, again, to retain talent. Now everyone wants the flexibility of working from home, so we don't see that going away anytime soon. And what happened with the pandemic, and even before the pandemic, with employers who might have permitted work from home setups, companies can sometimes be a little lax in their policies when someone is working from home. So, you know, typically in the office, there are very carefully thought out protocols, rules, technology that prohibit sharing of information that really should not be shared, or at least hopefully that's the goal. But when you have employees working from home, especially the way it happened with the pandemic, when all of a sudden, you know, virtually everyone was working from home, it was very difficult for companies to get up to speed on what should our protocols be when now, you know, 98% of our workforce is at home 5 days a week. And on the flip side, employees sometimes would make assumptions about what would be appropriate at home that might not be appropriate at work. You know, it's easier for me, let's say I don't have my work computer set up to attach to my printer, so I can't print a document as easily as I would like to. Okay, let's send it to my Gmail because I know that my phone is set up to my home printer. I can open my Gmail, I can print that document. So I think a lot of employees, not even employees who are trying to be bad actors, trying to misappropriate documents, might just be a little bit more lax, might not have understood why things were a little different, and there were still protocols that had to be complied with in an at-home environment. So that was the challenge that we were seeing with employers who all of a sudden had their workforces largely at home. Next slide, please. So I won't go through all of these bullet points because obviously there's a lot here, but there are some challenges working from home or remotely. Obviously, unsecured networks, whether it's in an employee's home or if they're working at Starbucks or some other coffee shop down the street. Unsecure personal devices, again, I think most companies now have policies for use of personal devices, but some employers were perhaps lagging a little bit at the time when all of a sudden everyone was at home working using their personal devices. Cloud storage, again, a lot of this is unsecure, and sometimes employees don't even understand that things are syncing automatically from one device to a certain account. Printed materials, electronic storage devices that are unsecure. There's a lot of technology that, again, if you're not ready for it and if you don't have policies in place, this can create a challenge, especially with employees who are all of a sudden at home. Unsecure Zoom or not Zoom, unsecure conference call lines or video conferencing platforms. I do think now that has gotten a little bit better. I think a lot of companies have realized that they need to tighten the security of their platforms. But in the beginning, again, it was really the wild, wild west. Increased visibility in public. This is something that I think is really important. And again, it doesn't necessarily mean that an employee is intentionally trying to do something bad, but in the office environment, pretty much the only people that are coming in here are the employees. So if I have something on my desk, it's not a terrible risk because most of the people who are going to be coming into my office are my coworkers who might have access to that information already. But when you're working at home or at a coffee shop, somebody can peek over your shoulder and see that, roommates, partners, there's just more options for people who really shouldn't get access to that information to see it. So let's go to the next slide. We're now going to start to discuss a little bit what protocols and what actions can be taken by employers to help prevent trade secret misappropriation. So this is a bit of a roadmap. I won't get into details on all of these because Kate's going to be getting into the details on some of these. But just to walk through identifying trade secrets in advance, I'm going to talk about that in just a minute. Agreements and policies and handbooks. We've already talked about this a little bit, but it is really important to have very clear guidance on what employees can and cannot do. Again, this gets back to Kat's point earlier about reasonable measures. And I think most courts are going to want to see, at a minimum, that there were policies in place saying this sort of information is confidential. You can't use it outside of the company. Onboarding and offboarding employees, this is really important. It's the first time somebody comes into the organization and perhaps the last touch point you're going to have with them on their way out. Again, Kate's going to talk about that in more detail about the sorts of things that will be important at those touch points. But that is a key time to educate employees on their way in and on their way out as to how confidential information needs to be protected. Obviously, sharing information on a need-to-know basis. Perhaps it goes without saying, and yet sometimes we see in litigation that something that was supposed to be a trade secret was widely available to everyone within the organization, even people who did not need it. That's never a good feeling as the person who's trying to litigate. It's a great feeling if you're on the defense and you can say, clearly the company did not consider this to be the keys to the kingdom because every single person in the organization was able to view it. But needless to say, it's very important to figure out who really needs access to certain pieces of information. Again, secure technology, network, facility. This is very important. Technology has changed a lot, again, as we mentioned earlier, and it's important to stay abreast of the latest technology, new ways to protect your trade secrets, new ways to detect trade secret misappropriation. That's all going to be considered when a court is looking at a lawsuit and saying, did the company take reasonable measures to secure this information? And then finally, acting quickly when necessary. We hope you don't have to deal with a trade secret misappropriation lawsuit, but if you do, you need to do it quickly and you need to do it efficiently and find a way to convince the judge that what happened here needs to be prevented going forward. Again, Kate's going to talk about that in a little bit. Now, this applies across the board, pre-pandemic, post-pandemic, whether you have employees in the office, out of the office, but it is particularly important when it comes to remote workers for all the reasons that we were just talking about. So I am going to talk a little bit about trade secret identification and why it is important. So if you are involved in a lawsuit where you need to assert a trade secret misappropriation claim, most courts now are going to require very early on that the trade secret be disclosed with reasonable particularity. And the reason for this, of course, is that the parties who are being accused of trade secret misappropriation need to be able to defend themselves against these claims. And so they need to know what it is that they are alleged to have misappropriated. And again, most courts are requiring this very early, sometimes before any discovery can get underway. Even in some cases at the pleading stage, in your complaint, you need to define with particularity, reasonable particularity, what the trade secret at issue is. Now, this is obviously a challenge because, as Kat mentioned, even in litigation, you don't want to describe, hey, here's a picture of the diagram with the things that we think are secret. You don't want to be filing that publicly in court. So it's a bit of a balancing act of figuring out how to define it enough that you can say to a judge, the defendant knows what we're talking about here. You, Your Honor, can get the sense of what we're talking about, but we're not disclosing publicly the specific details such that we're losing all protection. This is important for two reasons, identifying in advance. Number one, like I said, when you have a trade secret misappropriation claim, you need to move quickly. And often I find as outside counsel, one of the biggest challenges is learning the technology, because it may be something that I am not personally familiar with, learning the technology so that I can then convince a judge who might be even less savvy technologically than I am. This is what the business does. This is what the trade secret is, and this is why it needs to be protected. But if you haven't in advance identified and cataloged the trade secrets, sometimes it's difficult to do that. And again, at the beginning of a case, when you're trying to rush into court, you're trying to get an injunction on file, you don't have a lot of time to educate your outside counsel or to educate the judge. But the other thing is, we find that companies who do a really good job of cataloging their trade secrets and determining who has access to what, they often have an easier time detecting misappropriation. And again, that's the name of the game here. If you can stop it before it happens, great. Goal number one should be stop it before it happens. Goal number two is detect it quickly. And goal number three is, if it's already out the door, move quickly in litigation. Now, the last bullet point you'll see on this slide, trade secrets typically are not static. You might have on January 1st of this year, let's say 376 pieces of information that the company thinks this is actually a trade secret. This is something that is so important, so gives us such a competitive advantage that we're going to consider this a trade secret. Every day, your employees are creating new information, new inventions, new things that help improve your products, improve your services. So you can't just assume, all right, we did our trade secret identification. We have a list. We know what we're talking about in January of 2023. We're good until 2030. And you don't need to necessarily be updating this on a daily basis, but it is something that throughout the year, you should be thinking about, do we have any new special things that we need to consider a trade secret, and let's find a way to catalog that. Next slide, please. One of the best ways we think to do this is through a trade secret audit. And typically a trade secret audit would involve engaging outside counsel and really digging in over the course of weeks or maybe even months in some cases to figure out, one, what are the trade secrets that the business needs to protect? Are there things out there that the business folks aren't really thinking of as a trade secret, but when you get all the relevant heads together, you realize, well, no, this actually is something that's so important to us, we can't risk it being shown to a competitor. We need to treat that as if it's a trade secret. Looking at policies, agreements, figuring out what the holes are, making sure that the trade secrets that have been identified are really only limited to those with a need to know. Like I said, this can be a lengthy process, but it really does help in the long run, and it pays dividends because it makes it easier either in litigation or just in the detection of trade secret misappropriation to figure out what is really important, who has access to it, what are the protections in place. And then finally, we've been talking just about making sure that your trade secrets don't go out the door to a competitor, but the opposite is true as well. When you have new employees coming in, you want to make sure that they're not bringing trade secret information from their employer, their former employer, because you don't want to be on the side of someone being sued and saying, well, our former employee left with this really important formula and they brought it straight to the new employer. That is litigation you don't want to be embroiled in. So that's one of the benefits of trade secret audits. I think, Kate, now I'm throwing it over to you to talk a little bit about some of the other options.
Yeah, and before you go to the employee agreements, just a couple of notes on the audits. This could be a whole other webinar. Don't have a lot of time to talk about it, but this can be daunting for companies, and it can be a very broad audit, or you can start with a small division or one division within your company, depending upon the size of the company, and getting into a regular cadence of these, whether it's division by division, alternating, every couple of years or every year. It is critical to help you understand what you have and how to protect it, as Dawn points out. And the fact that you've done an audit, and if you've done it under privilege, all the better, obviously. But the fact that you've done it is something that a court will take into account as it reviews whether reasonable precautions have been taken. It's one tool to show the court that you've used to protect. So you can start small and broaden it, but it's a really good practice to get in, to put into a natural cadence at your company, and to work with your business people, IT folks. A lot of this is IT dependent, all the things we're talking about in terms of our IT policies and protocols. You will need, at companies, you will need your IT folks to work with you hand in hand to make sure you've got the right technology in place, reasonable technology given your circumstances, and then setting up these audits to work with IT and HR is a good idea as well. But thank you both, Kat and Dawn. Nice setup for the next pieces. So Dawn mentioned, and Kat did as well, the employee agreements, also part of the toolbox to protect trade secrets. And again, we won't go into all of these in vivid detail today. We don't have the time, but base level confidentiality agreements, non-disclosure agreements, making sure that your employees and your business partners are entering into confidentiality agreements to ensure that they're aware of how you treat your confidential agreement, that they're not to disclose it without consent. There's all kinds of provisions that would go into it. These agreements are under scrutiny as well, as Dawn mentioned. There's lots of statutory protections for employees, what they can't be prohibited from disclosing in terms of their NLRA rights, as well as speak out acts that are in place now, SEC provisions. So it's important to have counsel review them to make sure that they've got all the appropriate carve-outs that are required by statute, both federal and state statutes now. But very critical at base level to have these types of provisions, or these types of agreements, as well as policies in place, not just written and signed agreements, but employee policies that make sure that folks are aware of their obligations. Return of materials agreements, fancy way of saying make sure everybody gives your stuff back on the way out, employees, in terms of any information they may have on their computers or hard copies. That's rare these days, but it's mostly electronic copies these days. But also, again, vendors, business partners, all of that stuff ought to be thought about as you work with people to share your confidential information. They ought to be agreeing not only to keep it confidential, but also to return it at some point in time after your relationship has ended, whether it's an employment relationship or a business partner or a vendor, whatever the category is. But make sure that you're thinking about that as you enter into arrangements with folks to share confidential information and trade secrets. Invention assignment agreements, this is beyond my bailiwick. It's more in the IP lawyer, patent lawyer, copyright lawyer, but folks that are working with you, both as employees and again, business partners, make sure that there are invention assignment agreements in place and that you're not having people working for you, working for your businesses and developing ideas on your dime and then walking away with that and walking away with information that they've used, confidential information. There's a nice checklist to go through the types of protocols and agreements that you have in place to make sure the invention assignments are covered as well. Restrictive covenants, non-competes we've talked about, they are still, with the exception of a few states now, they're and counting. It's changing by the day. This is the flavor of the day right now with legislative activity to reform and or ban, but they are still, non-competes are still allowed in many states. They're governed by statutes in various states, and where you are allowed to have them, there are certain restrictions in place and reforms put in place, but they're still permitted, and they're still a very good way of protecting trade secrets if they're allowed in your state. It's a much easier case to prove. Dawn mentioned early on the difficulty of trade secret misappropriation cases. They're expensive. It's once the trade secret's out of the bag, it's tough to put back in, and it becomes a damages case. With a non-compete case, you can, if you have an enforceable agreement, you can prevent the person from joining a competitor, at least temporarily, until you get to trial and prevent disclosures from happening. So don't run away from them yet, and told. Just make sure you work with counsel to make sure they're well tailored and permitted in the states in which you're doing business. And we work with a number of employers across 50 state, 50 state workforces to make sure that their agreements work across the country. Forfeiture for competition, a little bit different. Maybe this will gain more popularity as formal non-competes become under attack, but this allows people to go to a competitor. But if you decide to compete, you forfeit certain rights, certain equity grants, for example, bonuses, however the particular forfeiture for competition agreement is drafted, and whatever the target of it is. It's a choice by the employee. You can go compete, but if you've gotten an equity grant or a bonus or whatever it may be, the company has the right to claw it back. So it's an incentive. It's not a prohibition, but an incentive not to compete, and really worth considering at least in your equity agreements. Customer non-solicits and employee non-solicits, again, they need to be very narrowly tailored. They're being targeted by many state statutes, as well as the Justice Department in terms of antitrust restrictions, to make sure that companies aren't agreeing with each other not to solicit each other's employees. So they too are, it's very important that you work with your counsel to make sure that you have the right provisions in place and that they're narrowly tailored and not running afoul of statutory requirements on the state level, as well as sort of this antitrust heightened focus that has occurred in the last couple of years. No hire provisions, very similar to what I've just mentioned in terms of antitrust concerns there. Has been typical in terms of settlement agreements to reach agreements in disputes, but that too is under fire from the Justice Department, so be careful there. And similarly with non-disclosure agreements that as we've already mentioned, and confidentiality agreements. But all of these remain viable protections, tools in the toolbox. You just have to be careful how you use them and work with your counsel to make sure that they comply with the many laws that are out there and ever evolving. Next slide, please. So BYOD, bring your own device policy. This is, these policies have been around for a long time, and they're becoming more and more relevant, obviously, with remote environments. It's important to have to make sure you're updating these and making sure that your workforce is trained on what they involve and cover, and make sure that they are appropriate for your particular workforce and the various categories of employees in your workforce. If you have a BYOD policy, I imagine most businesses do these days, and if you don't, you should think about it. If you have employees working off of their tablets or smartphones, whether it's an iPhone or other device. Many people are conducting business off of these devices, and if you don't have a policy in place, you really should. That spells out the parameters of what they can and can't do, and what you can do as a business or employer with those particular devices, so that everybody's expectations are quite clear and people's privacy rights are respected, but your information is protected at the same time. So here, as we say, specify which devices are permitted. Many businesses allow smartphones and iPads, but nothing beyond that, and don't allow thumb drives or hard drives, external hard drives. That's something to think about. You know, as Dawn mentioned, you don't see the banker's boxes of documents going out the door as much as you used to. I had lots of cases like that back in the day, but now it's people just inserting a thumb drive or uploading information to an iCloud account or whatever it may be. But a BYOD policy really needs to lay all of that out, so that your employees know what is permitted and what's not. And when it comes time, if there's been a violation of the policy, you can't be criticized for not notifying people what restrictions were in place and what the employer is permitted to do once an employee leaves. Provide clear restrictions on use and transfer of company data. I think Dawn mentioned this in terms of using, sending information home to personal email accounts. That went on for a long time until recently at many businesses. I know here we get a block if we try to do it. So now it's, we have VPN access that we can get onto our networks and work from home in a secure setting, as Dawn mentioned earlier as well. Explain, I referenced this earlier, explain when you can get access to the device and the data on it. Someone is leaving. There should be a policy in place that says that once you've given your notice, we're going to shut off your access to information, and we have the right to remediate the data, our company data that's on your device, whether it's an iPhone or an iPad. All of that should be laid out. And work in this policy to exit interviews. We'll talk in a moment about exit interviews and the processes that you should put protocols in place, but make sure you're reminding people in exit interviews of the BYOD policy and what you're permitted to do and not to do. And in that policy, explain that the company has the right to investigate employees' use of an access to confidential information through these devices. And if the person leaves or the company is on notice that something has gone wrong with the employee in terms of improper access or uploading, whatever it may be, or knowledge that the company has gone to a competitor, that the company has the right to remote wipe those devices as soon as they're on notice. So if you don't have a policy, please think about putting one in place. If you do have one in place, make sure you're updating it to sync with your IT policies and your employee categories as your employment workforce expands or changes. Next slide. So some of this has been referenced, and in the interest of time, we won't go through in vivid detail, but remote work best practices, Dawn mentioned there are a number of video conference platforms that are available. They've improved dramatically in terms of security settings. So do work with your IT groups or your IT partners to make sure that you've got the most up-to-date and secure platforms that your employees can use. Train, we talk about a culture of confidentiality. It's something to start with your workforce from day one when people join you, and continue to train on your confidentiality obligations. Ensure that you've got written policies in place for remote work protocol. What are folks permitted to do at home? Are they permitted to share documents from home computers, access documents at home? All of the things that people do in your office environment, think about how that's translating in the remote environment and what makes sense and what doesn't. Monitoring is a sort of a nasty word to some, but when you have folks working remotely and have access to your system, you should have policies in place that tell your employees that you're permitted to do that, and you will do that, so that there is some some sense that not people just aren't working on their own, and there is some access by the employer. I mentioned VPN, allow remote access through secure VPN connections with encryptions. Again, the technology of this is beyond our expertise, but it's well known to IT departments how to set these up and educate your workforce on how to use them. We talked about public place working. It can be dangerous. People can look over people's shoulders. Encourage your employers to get privacy screens on their monitors. It's a very easy, quick fix for people looking over shoulders in coffee shops and on planes. And Dawn already mentioned sort of the sharing your home space. There's a story out there, maybe it's urban folklore, of an associate at a law firm working at home and working on a corporate deal, and roommate sees all this going on and does some trading based upon what they learned. You don't want those situations to occur. So be mindful of and put policies in place and train people on how best to work remotely to protect your information. Next slide. Dawn alluded to this too. It's very important that people are trained on how to protect your trade secrets while they're in your employment. As people come in the door, start that training and start that critical look. Make sure you have agreements in place as payments and policies that people are acknowledging as they come in and join you as a new employee, that they're not bringing anything with them. No confidential information, no trade secrets. Have them affirm either in offer letters or agreements, depending upon the level of employee, that they're not doing that, and they're permitted to join you, that they're not violating non-compete agreements, as far as they know. But start that discussion as soon as they come out. Hand out the policies that impact confidentiality and trade secret protection, computer access, the computer usage policies. Make sure those are part of your hire packets, and don't just hand them, a stack of things electronically or in hand. Make sure they're pointed out and signed on to, so that people are aware of them and not just leafing through a packet, not paying any attention. Interactive training, not just at onboarding time. Make it again, a cadence of training, that it's regular and updated over a period of times, and have people sign onto those. There are lots of e-modules out there that are inexpensive and pretty good. There's also HR training on this that makes sense. Make sure your employees are signing off on this, so you have a record that they've done that. When you get into litigation, those are among the first things that we ask for, in terms of showing that the employer rather, the business has taken steps to protect information. Are these signed off on policies and training? It's great evidence, and it's easy evidence, inexpensive evidence to produce during a lawsuit. Marking things as confidential. You can do this electronically and internally as you protect your information. Distributing information out to employees on a need-to-know basis, as Dawn mentioned. Make sure confidential things are marked confidential. Again, easy to do, and another thing to point to as if you have to litigate these types of cases, that this care has been taken to show that this is a document. If we have a document that has no marking on it, that's confidential, and employees walked away with it or used it in a new job, it's tough to make the argument in court that the employer hasn't even taken the step to put a stamp on it that it was confidential or protected.
If I could just jump in real
Sure.
quick there, just stamping something confidential doesn't necessarily make it confidential. So, if you label it that way and you're still giving it to everyone under the sun in the organization, even people who don't need it, that doesn't necessarily mean it's going to be viewed as a trade secret. But I do agree with Kate. It's great in litigation if a defendant says, I had no idea that document was confidential. And you can say to the judge, look at the bottom of this slide deck, for example. Every single slide, it's marked confidential, do not disclose outside the company, or whatever the marking is. So it does make it so much easier. It's not the dispositive factor, but it makes it much easier that at least this person knew it shouldn't have been going out the door.
Yeah, it's, all of this, it's a very good point, Dawn. It's all of this, these are tools and steps in proving to a court, or convincing a court that the business has taken a number of steps to protect information, and The more you have, the better it is. But marking something confidential and then just handing it out willy-nilly to everybody who really doesn't need to see it is going to defeat that branding of the document for sure. Let's go to the next slide. So exit interviews for the other side, other end of the employment relationship when someone leaves, critically important. May seem like a pain in the neck to do, but it is the time to remind your departing employees of all the obligations they have. Also to ensure that they are returning everything that they have, not only devices, but information. And, set up a checklist that you're going through your folks so that it is consistent and standard across the board, and that you do it every time someone leaves. This becomes evidence as well in these cases. You're able to point to the fact that an exit interview occurred, that you took notes of that interview, the employee signed off on a checklist of items as part of the exit interview. One part of that is disabling the access to company computer networks, disabling the devices that they're using, as we've mentioned already, making sure usernames and passwords are given to you for purposes of a company device that's being turned back in. Employee no doubt has a password to get into it. One would hope that your tech group has those cataloged and tracked, but make sure you get it from the employee leaving. If the employee is subject to a particular agreement, whether it's a non-compete or any type of agreement that we referenced here, show them, give them a copy of it. Don't just say that, oh, by the way, back in the day when you signed this, you signed an agreement. Give them a copy of it. Make sure they see it and go over it with them. Consider sending, if the person is going to a competitor, ask them where they're going. You have that right. Many agreements that we work with employers on include in the agreement the right to ask where someone's going. Even if you don't have that, you have that right to ask. They may not tell you, but at least you've asked. And if they lie to you, that's also very good evidence if you have to move to enforce a trade secret agreement or a non-compete agreement. It's not a good fact for a departing employee. Another thing to consider when people are leaving, not only a reminder to them, but a reminder to whomever they're going to, to the new employer, to remind the new employer that this particular employee has obligations to the company they're leaving. Think about whether if that's permitted under an agreement, all the better. If it's not, think about whether that, the tone of that letter. You don't want to risk an interference with contract claim by a departing employee, that a nasty gram has gone to their new employer, and the new employer has decided then not to hire them because they're worried about the letter they've gotten from you. So be careful of the tone depending upon what the situation is. Work with counsel on that. Critically important, we're running out of time here, so I'm going to go quickly. When someone leaves, make sure that you have preserved their email boxes as well as their computers and their electronic devices. It's not always practical to just take the device and put it on a shelf and leave it there for a period of time while you wait to see whether you might have litigation with this employee, but make sure the devices are imaged before they're repurposed, and have a chain of custody certificate in place, or work with your IT folks to make sure that there's a documented chain of custody on what's happened with the device and how it's been imaged and when that occurred, so that
I just realized I didn't give the CLE code, and as we're
all right, you better
into the hour,
do it.
let me give that quickly.
Sure.
The CLE code is SS as in Seyfarth Shaw 7991. That's SS 7991. Okay, go ahead.
Very good. People would be upset without that CLE code. So can you just go back to the last slide quickly, please? And then I think I mentioned the exit interview certification, really good evidence and a nice protocol to put in place just to make sure you've gone through the list of things. And next slide. And then finally on this, just quickly, we've talked a lot about this, the remote employee when you're doing an exit interview. The difference is there, obviously, you're not sitting across a conference room table with someone. Consider doing it on a video, consider having someone with you to have a witness. whether it's a business manager for that particular employer, an HR employee, HR business partner. Very good idea to have two people present, particularly when it's not an in-person meeting, and arrange for remote remediation of company data, arrange for materials to either be sent back, send a box and FedEx, UPS, whatever it may be to get the employee's material back. Offer, depending upon how sensitive the information is, offer to send a courier to the house and pick things up. We've done that in very sensitive situations. So you have to sort of consider the circumstances and how it is different when someone's not in the office to have that conversation. Next slide. And then if something happens, Dawn alluded to this, in the case of theft, loss, or breach, don't sit on your hands, move quickly, talk with your in-house lawyers, your outside counsel, make sure you're securing information, assessing damage, get a forensic expert involved, whether it's in-house or external, to make sure you're locking down the business assets, the forensic, and doing forensic searches on what's happened from printing to email activity to downloading activity to uploading to cloud accounts. All of that stuff can be looked into pretty promptly and inexpensively right off the bat. Send cease and desist letters promptly to the employee as well as to wherever that particular employee is going, to put people on notice that you are going to enforce their obligations. And where necessary, be ready to file legal action. It is companies that sit on their hands and don't get into court quickly enough are criticized as not being quick enough to protect themselves. So time is of the essence. All the things we've talked about to do in advance helps that process when it comes to running to court. So think about putting all these elements in place so that it's not a crazy situation when you've got counsel involved trying to pull these things together. It's time is of the essence. And take the opportunity to reevaluate what might have gone wrong with this particular employee. How were they able to either steal or walk away with the particular information that's at issue? And just to wrap it up, just remember the protective measures that you put in place need to be reasonable, only reasonable, but a court's going to look at the size of the employer, the assets available to it, the sensitivity of the information, and make a judgment on whether you have taken reasonable precautions to protect. So fit a lot in there in the last few minutes. We want to be respectful of your time. You can go to the next slide. We don't have time to take any questions, but we will be sure and answer any that you put in the chat. You can follow up with any of us by email, which are on the slide, is on this last page of the slide deck. Those will go out to all the participants today. We covered a lot of ground. Thanks for sticking with us. We appreciate you attending, and look out for the next webinar on our Trade Secrets blog on updates at the FTC and NLRB level. Thank you for your time, and thanks for joining us.